And then Governor Ferguson also today signed a bill, HB 1390, wrote about this earlier in the month. This repeals the Community Protection Program, and this concerns individuals with developmental disabilities who have, in some cases, committed acts of sexual violence. So then they are in this community protection program. Um, these are crimes that, if they didn't have a developmental disability, a crime of sexual violence, they'd likely be behind bars or would have served time behind bars for that crime. But because of their disability, they instead are enrolled in this program and housed separately. Say it's an adult group home for folks with disabilities. Well, those with sexual crimes and their background are housed separately. Well, under this bill, they're going to be sort of mainstreamed, if you will, in with folks in the general population with developmental disabilities. There are some concerns there about the risk to a vulnerable and already vulnerable population. So, we're going to share some of my conversation with Senator Leonard Christian, who took a lot of heat because he intentionally invoked the R word, referring to folks with developmental disabilities, during his Senate floor speech. And he did that provocatively, because they knew it would get attention. It did get him a reprimand, even from some leadership from his own side of the aisle. But he explained to me why he felt it was so important to do that. And really, it was just to bring attention to the bill that was kind of flying under the radar. I mean, honestly, if he hadn't used that slur, if you will, as some people refer to it as, it wouldn't have got our attention, and I wouldn't have written on the story. Again, that bill signed into law today by the governor, so I want to bring that back to your attention today. All right, now to House Bill 1390. Governor Ferguson signed this bill into law today. It did not get much attention during the legislative session until there was, an offensive remark, a slur, the R word used by a senator on the floor to get some attention to it. This bill repeals the Community Protection Program, and this concerns individuals with developmental disabilities who have committed acts of sexual violence, such that if they didn't have a developmental disability, they would have served time for it or be currently locked up. But because of their disability, they're in this community protection program. Some restrictions on them, it might be even like home ankle monitoring, that sort of a thing, or they can only, go out into public with a caseworker with them, sort of supervised. So they've got, some restrictions. So this is a bill that is, again, repealing this in its entirety and placing them in with general population of those with developmental disabilities. So this is the bill's sponsor, Representative Roger Goodman, who was speaking just ahead of a public hearing, giving some testimony about his bill on January 29th.
I was a little hesitant to sponsor this bill when I saw we're repealing the Community Protection Program. Why would we get rid of the Community Protection Program? And I was actually confusing it with the Community Protection Act, which was enacted in 1990, and that's sex offender registration. So we're not talking about sex offender registration. This is a special, as was described, a waiver program that began to evolve back in the mid-90s and was sort of made official about a decade later. And I can actually read the intent, which was to provide a structured therapeutic environment for persons who are eligible in order for them to live safely and successfully in the community while minimizing the risk to public safety. Sounds good, and yet as the program has evolved, it has become coercive. They say it's voluntary, but once you're in, you can never get out. As a matter of fact, I'm just reading from the report, No Way Out, from the Ombuds, which more than 15 years ago reported on this program just is not working as intended. Of the 400 individuals who were in the program, about 10 ended up being released, so the other 390 are sort of trapped in the program. Quite coercive, and not the services provided to them are really not individualized, and not person-centered, and also there are some conflicts with federal law. So it does not necessarily mean that DDA won't be providing the services, and yet they won't be providing the services in such a restrictive way that hasn't been successful and also in violation of federal law.
Now, during floor debate on this bill on the Senate side, Senator Leonard Christian used the R word, some found offensive, but he used that word intentionally, he told me, to get some attention to the bill that was otherwise really under the radar entirely. Um, he was issued, it was some kind of a formal reprimand by members of his own party, basically condemning his offensive language. Some other members, even from his own district, which is in the Spokane area, even other Republicans came out publicly and said, we were offended. This was not the way to bring attention to it. But um, I suppose in some ways he felt it was worth the risk in putting himself out there because he said he's very concerned that putting those with, sexually violent pasts in with very vulnerable, those with disabilities that are very vulnerable to begin with, and then you're putting them in with folks that have this, interesting past. He said it was just too risky to avoid, putting himself out there and using that word to bring attention to it.
As I thought, it's like it's just going to get buried. They got the votes. It's just going to get buried. How do I draw attention to this incredibly important topic? And what would you do if somebody you loved was going to be sexually, assaulted? You pull out all the stops. There's, you do everything you can in your power, and you don't just say, well, I did a vote and I get a little speech and I'm done. No, you do what you're sent to Olympia to do. You protect the people. And it wasn't meant to be disrespectful or hurtful to anybody. It was to and get some attention from the mainstream media on how horrible this bill was going to do. And look, if you had the choice between hurtful word and physical harm, where are you going to go? To me, it was a no-brainer. And it's sad that some the other folks out there have gone the way they have, but there's the reason, there's the difference between a public servant and a politician.
But the bill has been signed into law. Governor Ferguson did that today. The legislative intent of the bill basically says it's ending the CPP to allow clients of the Home and Community Living Administration within DSHS to obtain less restrictive service options. So DSHS has to develop and implement this plan to transition all of these individuals participating into the program into other services or programs by the end of this year, by December 31st, 2026. So it's going to be kind of a rapid um, a transition of these folks into other settings. And I'm told there's somewhere around 400 of these individuals that they have to find alternative settings for, sort of mainstream, if you will. We're going to be watching the bill closely. Again, it didn't get a lot of attention, but if there are the consequences that Senator Christian and some others are, have raised concerns about, that's going to open up the state to potentially massive lawsuits. And we already have a lot of those going out, don't we? And we didn't do tort reform again this year during the legislative session, but I'll get off my soapbox on that one for a minute. That wraps up today's episode of Washington in Focus Daily. Thank you for watching. Check out all of our stories at the Center Square Washington page. Have a great day.